with the program here and what we are exactly covering in this program, and specifically how we will be assess the perspective of the labor law, the future labor law, the future perspective of the labor law in India. So for that, we have to assess the norm of the existing labor law. There are many pain points for the organization as well as for the employer specifically, because any organization, they have been headed by some individual, some people. So that's why that are the pain point for that. Even though after the 76 years of the independence, there are the many reforms has been done, but still the law are still panning for the organization. So that when we have to understand the actual perspective of the labor law in the future, so that we need to assess the present norm as well as the issue for the organizations. So that I'm sharing with you the schedule one time, what we are covering in this program and how it is going to be forward and how it will impact really your learning, that you can implement that from tomorrow when you revisit to your office and join is back after the weekend and the weekly off or weekly holiday, the Sunday, and then after you can implement that system which I'm going to be shared with you here. And so this is the schedule which we are covering in this live session today, and there we have divided in the 3 different rooms, or you can say it in the different sections, where in the first section we will assess the norms as well as the norm of the labor law. Even though for understanding the future labor law which are going to be implemented soon, for that we need to understand the norm of the existing issues with the existing labor law. Then we can find a solution together for the future when we will be ready and prepared for the future perspective of the labor law. And then we together, we are learning today, and then tomorrow individually you can be ready for, make your organization ready for accepting those new norms and new changes, and which are known as the reform, when they will be implemented. However, the date is not confirmed, but still it is expected from the new financial year the new labor codes will be implemented. Then further, in the module or the section number 2 of this program, where we will practically develop a system what you have to do to overcome the issues which may be forthcome with the implementation of the new law as well as with the existing labor law. There are the certain pains available, and how you can overcome that, we will go with a systematic platform development here, so that you can implement that in your organization, at your workplace, what you are learning in this master program today. And whatever the templates, whatever the system, or whatever the key templates and the format we are using in this practical session, that all you are getting from this live session. So after completion of this program by 6:30 or 7, how far it will be go, then you will be get all those templates which we will share with you in this live session today. Then the third section we have specifically kept for the question and answer section, so that whatever understand that with whom today you are interactive. It is not as a person, me, and the platform exactly who we are, when we established, and what are our mission, vision, and exactly what we do and what we serve for the society specifically. So here you are interacting with the platform which we have established in May 2020. So it is now 1.5 year old organization on the name of SBR Learning Studio. So you can name it as the Success Beyond a Reason. So possibly it was established with the objective that provide the best learning platform to everyone within reasonable cost. When we established this platform 1.5 years back, so it was specifically with the objective to the online or digital learning platform. But after then we are also expanded it to some physical services also, physical trainings also, then other the HR and corporate as well as the legal services throughout India with our different partners. And this organization we have established based on the one vision. So we are on the vision specifically, where we want to educate with their professional skills which are required in the future for the future requirement of the skill force in India. So there we have the vision to educate 100 million people by 2040. And with this vision of the 100 million people by 2040, we are on a mission. So that mission is every year we have to cover at least 25,000 students everywhere. So it is not just in the HR domain. So there are the any other areas where we are also developing the people. So I'm also sharing that with you. So where are the what are the different types of the platform where we are developing and trying to develop the people for their skill, the future requirement, and the balancing with the future requirement of the skill force. Then this organization, when we have established, so we focus on the value. So value is specifically who are becoming the customer of our, as well as who are associated with us. So we are looking forward with them the long term association for their development. So everything where we are also connecting with the people who have already been started with this program. So there, as of now, in this program we have trained near about 600 people since July when we have started this program. So they all are connected with on our platform. So different types of the platform are there where we are connected. Then it comes to the what are the services basically we are offering to the organization, corporate societies, and individuals. So there we have different type of the service segments. So where we are providing the licensing services, then corporate consulting services, individual and group mentoring services, professional resume services, then digital solution and the digital library. So these are the, as of now, the services we are offering to the society, corporate, individuals, and group. Then specifically when we talk about the with the mission, when it was started in the 2020 May last year, so that was specifically focusing on the digital platform where we are offering the 5 types of the solution for the individual as well as the organizations. So there we are offering the personal development program, professional development program, entrepreneurial development program, the leadership development program, and then the business development programs. In this 5 different domains of individuals and group development program, we are offering many development platforms and the courses there, so that are available at our platform. So there you can also check out that our website, so where you can connect to us. And at present we are presence our presence is on the 5 different platform, where one you can also check out at our website, the main our website, which is on the name of the www.azuretrend.com. And then you can connect with us, all our team, our mentor, our promoters, with the emails. So that email is specifically svrstudio2436 at gmail.com, which already shared with you. All the communication has been received from that email with you. And then we have one digital academy, where all the digital program which are landed there, and they are provided the lifetime access to the member who are joining those programs. Apart from these 2 platforms, then we are also available for some social media platforms, where we are providing the insights update related to the 3 different domains. One is the soft skill learning, then specifically the area of the HR learning, and then there the people who are aspirant of the developing and seeking the ideas from the global leaders, but they don't have time to read the book and the big bundles of books. So for that we have one separate social media platform where we provide the small summaries of book. You can check out that on the Google, it will be easily available there. However, with the mail you have been get the linkage of all those platforms where you can connect with us, and further these free insights and the where we provide the different types of the updates which I have mentioned that. Then mainly when in the 2020 May, when we established this as that organization with the objective to providing a platform for the digital learning. So in that we are providing the 5 type of solution in there. As of now we have more than 15 number of the live program available. So you can also check out that, because I'm not sharing it in detail here so that we can cover all the practical session of this program. Specifically this program we have designed for. to me, with whom you are interacting. So my name is Srinivasan and I have more than 18 years of experience in the HR domain. I have worked for the Indian multinational organization as well in India and Southeast Asia for more than 18 years. And now I am associated with the SBR Learning Studio as the facilitator, and specifically mostly the learning part and the training part related to HR as well as the labor law that I'm covering. So there are the other domain which are taken care by the other peoples also. So this was all about the SBR Learning Studio as well as about me. So now with the program here and what we are exactly covering in this program, and specifically how we will be assess the perspective of the labor law, the future labor law, the future perspective of the labor law in India. So for that, we have to assess the norm of the existing labor law. There are many pain points for the organization as well as for the employer specifically, because any organization, they have been headed by some individual, some people. So that's why that are the pain point for that. Even though after the 76 years of the independence, there are the many reforms has been done, but still the law are still panning for the organization. So that when we have to understand the actual perspective of the labor law in the future, so that we need to assess the present norm as well as the issue for the organizations. What brought you from this program today? So just write in the chat box one and two things. What brought you here in this program and what are your expectations? So just for 2 minutes, I'm expecting the answer from the maximum number of the people, and then we will start with the assessing of the issues and the pain for the employer with the existing labor law. When we assess the issues or the pain with the existing labor law, then we can properly understand the future perspective of the labor law. And the second section, accordingly, we can develop a system how you have to you can overcome from those issues in the future and such pains of your employer, how you can help them. And further, there is the impact on the career of the people who are responsible for assuring the compliance and the regulation of the labor laws in the industries. So quickly, just give me one and two clues. What brought you in this program today? And what is your objective to join this program? And further, what is your expectation from this program? So accordingly, in the second module or the second section of this program, we will practically design all that system which can help you to implement a compliance portfolio in your organization and assuring a good compliance in your organization, and so that you can be ready for the future perspective of the labor law. So here SMA 551F. So please, could you share your name also in the chat box? Rupika, hi Rupika. So your answer is to know the changes and update of the Shops and Commercial Establishment Act and the contract labor. Okay. So specifically, this is the main reason for brought you here. So please, the other people, Zamir Alam, learning and to get implemented the change. Good, because it is the specifically the learning program as well as the future perspective readiness, so that when the new codes will be implemented. So also I am also going to share with you the something which will be shock you what is going to be happen when these 4 new codes will be implemented, and why you should be ready. Means the organization should be ready before that to implement all those norm of the or regulation which are going to be changed on the name of reforms. Some part it is the reform, but some other part it is the bigger than that. So what is that? We are going to discuss that, and specifically developing a platform and system for that, so it will be easy for you to implement that in the organization. Vijay Kumar, he is brought to this program to get to answer and what are their objective from this program today, and what brought them to into what brought them in this program or the live session related to the level of compliance as well as the future perspective of the Indian law, how you have to comply in the regulation and facilitate them in the organization. So let's begin with the session now, what we are exactly covering here, and what are the pain point for the organization, and that is going to become that biggest pain for the organization in the future if that did not addressed properly. So that solution we are together here learning here, and so that you can implement that in the future too in this program. So first, for when we have to understand the future perspective of the that the labor law, even that is related to the existing labor laws, and then the four new codes which are going to be implemented very soon. So for that we need to be assess the present norms of the existing labor law, what those law and why still that laws are the pain for the organization. So there may be many numbers of issue, but one or two which we can just consider here. One is the considering the labor law not a good or the profitable work, and that's why there are a lot of the bad practices which has been adopted by the organization, but in the future such practices will not help you. You have to implement the norms in a systematic way. So that system we are going to learn today, and I'm sharing with you that session, and understanding and assessing the present norm related and the present norm and the pain of the organization related to the existing labor law. Then we can also understand the future perspective. When we have to understand the future perspective with the new four labor codes, so for that we need to be assess the present issues as well as the present pain, as we are learning studio what it is, and for the people who have joined in between now, and that the introduction part only. So let's begin in the session now, and what we are exactly covering, and specifically to understand the future perspective of the coming labor laws as well as the existing labor law, what are going to be happen with them and what will be their impact in the industry. So for that we need to assess their norm with the present issues and in the existing norm. So also here I have one or two questions for you in going deep into the session and just understanding the norms of and the nerves of the existing labor law. So what are the, because this program is specifically designed, however it is for the 2.5 hours only, but specifically it is designed with a platform. It will be help you to implement the system in your organization. Then here is one question for you. The question is, what are the four skill or the success skill of a labor law compliance leader or the specialist, as per your opinion? So that I will share that. However, I am not sharing that with this. During this program we are developing these success skills, four success skill of the labor law compliance specialist, also how you can transform these skills as your career unique selling proposition. So all that concept you are learning today in this 2.5 hours of a program. So just waiting for 1 minute, just seeking your answer for that particular question. So what are the four success skill? You do not have to go beyond four. There are the four major success skills for the labor law compliance specialist, so that you need to be write in the chat box. After that we will be go directly and jump into the assessing the present issue with the existing labor law and assess the norms of their why that are the pain point for the organization. And then further we will practically learn how you will be help the organization to overcome from such pains. So question I'm repeating here, just I'm waiting for 1 and 2 confirmation from any one member, so that we can jump into the understanding and assessing the nerves of the present labor law or the existing labor law and their impact on the industry, and that impact is the pain point for the organization. Why is that? So I will also clear that in just quickly. So it is 4:39, just for the 4:40 you just have to answer the any 1 and 2. However, that are the four skill which I am going to develop, or we are going to be develop here in together in this live session today. But you have to answer what you consider and what you think what should be. So it is not you have to share it exactly, but only you have to guess that what it should be. If you know, so that is okay. So we will also enhance that skill within you. And if you don't know, but you answer. So now just 20 seconds are there. Okay, one respond I received from the SMG 610F, update on the labor law and consistent in implementing. Yeah, of course, but exactly this is the base part of those skills. So what are those skills? I will share with you, and however I will not share with you, I will practically implement here, and so that that develop skill when you zoom back tomorrow to your office or organization, so that you can implement there. So here I am sharing with you the ready references where you have just minor changes and implement that immediately in your organization, so that you can develop all those four skills. So we will practically develop those skills in this section 2, which is specifically for the developing of the labor law compliance management portfolio, that are based on the 4 essential skills for the success of labor law compliance specialist as well as a leader. That can be the HR professional, that can you be the labor law compliance service provided. When you have those skills, that will help you in the future for your career succession. So I will also share with you how you can convert those skills as your unique selling proposition. So here, let's begin. What we are understanding first, just have a concept in mind. In India, even though in the globe there are the different types of industries available, if we divide in those industry in the different types of the industrial sector, so it broadly come into the 3 major perspective of the industrial sector. One, we can say at the primary sector and secondary sector, and third one is the territorial sector. So when we come with the scrutiny and the that divide the industries into the different 3 sectors, so it come to the in the primary sector, the industries which are normally in the processing of the natural resources. They are not big processes available, they just have the natural resources, just process them and then sell them to the customer. And then the second level of the industries, that are the secondary industries. Those industries are specifically in the covering a major of the industrial law or the industrial existing law are applicable to them majorly, and that are the industry where the maximum number of the processes happen, where the one raw part transferred to the another condition shape, and their operations are very critical, which is known as dangerous for the health of the organization, and that are also the hazard for the people who are working in that organization, and maximum number of the existing labor law that are applied or applicable for those industries. Then come into the third number of the industrial sector. So that sector is which we known as the service sector. So all the service sector, hotel, restaurant, ITs, BPOs, where just the only processing of the output happen. So that are the third type of the sector. So when we come and when we consider the perspective of the future and its impact of the industries, what are the changes happen in the future related to the labor law? It impact majorly the secondary sector, where the mostly the manufacturing industries come. So that's why in this live session today we are exemplifying the manufacturing industries. However, we are covering all the perspective related to the different type of the factories, different type of the industries, which are covering in all 3 major sectors, the primary, secondary as well as the territorial. So here we are covering and assessing the present norm in the industry specifically, as here I am sharing with you that for exemplifying the factories. So we are covering the Factories Act, their pain point for the employer. Then Shop and Commercial Establishment Act, industries which are not factories but they have their processes, they are the establishment, so that are covered under the shops and commercial establishment. What are their pain points, and that points why that exists and the organization are still not overcoming out from that. There we have developed some concept, we have developed some practices that we are not getting out from that trap. So that's why we means the who are the representative who are dealing and who are responsible for the implementation on the regulation of these existing labor law. and it is the pain point for the employer, because the employer is the ultimate responsible for implementation of these norms and regulation which has been prescribed in the different labor law, which will be applicable to the industries, even that are the factories, shop and commercial establishment, that is the plantation, then there are the mines, there are the dock works, the different type of the industries, when we divide that in the three different sectors. Then when you have the factories and shop and commercial, then there are the other connected law which become applicable to the organization when you comply with the norms related to the big and the primary law which is applicable to the organization, where you have to start any commencement. Without those law implementation, you cannot start any business. So there is a connecting law which you need to be assured and facilitate in your organization, that have also the different types of impact to the organization, and they are becoming the majorly the pain point for the organization. So now it is your means the people who are dealing with the labor laws and their norms which you have to practically implement in that. So you should be well aware about that, how to implement that, what are their consequences, and what you need to be assured. So we are going to be learn practically in this section 2. But first, the understanding the full perspective of the, or the real perspective of the future labor law in India, its impact on the industry. So we need to assess the norm of the existing labor law. So what is that? So let's begin with that. So as I discussed with you, so there are the three major industrial sector, even though that is not just in India, it is globally. And then there are the where the maximum number of the labor law are implemented or applied, that are the manufacturing and the factories. So first of all, so here just have a look on that, what are the different types of the circumstances, and secondly the regulation which has been prescribed in the law and that need to be assured by the organization or employer in their organization. If those norms are not implemented and assured, there are the different consequences for the employer. So that consequences are in the form of their imprisonment, and then there will be the impose the fine to the employer, and then after the cancellation of their business license if these norms and the regulation are not fulfilled. So when we go with the factories, so as of now, the maximum number of the industrial estate that lies in the industries in India, so it is mandatory for every organization who have the manufacturing setup, they need to obtain the factory license for that. With that approval, as well as their building plan approval, you cannot commence any business operation in that premises. And then after, you need to renew that restriction on time. If is that is not, so there are, it is considered as the punishable offenses for the organization. So offense will be 3 years of imprisonment and fine up to 2 lakh rupees if that thing happen. So what it will be, it will impact the three area of your employer. One is their businesses, when the license will be cancelled, so their business will be vanish or finish. When, and second, it is their individual identity or their individual aura that will also be impacted, and third one is their dominance within their client, their within their competitor, that will also impact. So these are the three area which will impact the organization, and third one is also the finance. So when you have paid to 2 lakh rupees for one single non fulfillment of the obligation, so that is the unnecessary paying of the amount. However, with the existing law there are many loopholes, but in the future that loopholes are going to be banished from the organization. But actually what is happening, what will be the actual perspective of the labor law, so that we will be assessed later on the existing labor law. Similarly, this is was the about the factories. Then it come to the shop and commercial establishments. Those are not factories, but they have the processes, they have the business, so that are organization or the establishment, they are regularized by the Shop and Commercial Establishment Act. And the Shop and Commercial Establishment Act, that is exactly not the central labor law, it is the state specific labor law. It is existed in every state where any business which is not the factories, that will be regularized by the shop and commercial establishment. Similarly, in the factories, so there, for any business commencement in the state which is not factory, that need to be obtain certain registration under the shop and commercial establishment. When that registration has been obtained and granted to you, there will be imposed a certain condition with the organization. Condition are that you need to be assured the employment of the adult worker, then there hours of the adult worker, then there are the certain restriction related to the double employment of the employee you are engaging in your organization, then there the condition for the prohibition of employment of children, then employment of young person, their hours of work, then the opening and closing hour, you need to be assured that which has been defined in the rules of the shop and commercial establishment act. However, there you require to prior approval, so accordingly you can open and close your organization. Here the wages for the holiday, and one thing that the organization, there is the like all those laws are also interconnected. Like there are the factories also, but factories act, they never define it anywhere that your weekly holiday need to be paid, but it is defined by the shop and commercial establishment, so that in the factories the weekly off need to be paid. However, the people or who are dealing with the HR, they have the concept that they need to calculate their wages based on their actual working day, which is instead of their holiday, rest of holiday. But exactly, you need to be whatever the minimum wage has been defined, that need to be calculated based on the full calendar month. And similarly, when these law like the shop and commercial establishment factories act, these are the law which regulate the working hour, condition of employment and service in the industries. When there is any open issue with any industry, even that is shop and commercial establishment, and that is with the factories, so that will be referred connectively, or they are connected to each other. And when the conclusion it does not by the authorities, when there are the any issue happen or any dispute happen, that both and that go to the civil court and labor court, when the decision or judgment made by the judge there, that will be based on assessing all the previous judgment as well as the different connecting labor law which regulate the same condition. Like the shop and commercial establishment regulate the working hour, condition of service and employment for the shop and commercial, and the Factories Act 1948 that regulate the working hours, condition and service for the factory specific. But the law are specifically regulating the working hour, condition of employment and services, so it will be referred when there is any issue and making the decision or judgment on that. And similarly, there you need to be facilitate the health, safety and welfare measure in the organization. And whatever the Indian labor law, their primarily objective is to that ensure the health, safety and welfare of the industrial laborer, even that laborer which we specifically in the corporate language we known as them, the blue collar as well as the employee. However, as per the law, everyone is the worker instead of the employer. That these are the condition you need to be facilitate in your organization, that are the obligation for the employer. If those obligations are not fulfilled under the shop and commercial establishment, so there is the provision of 1 lakh rupees fine and the cancellation of your business license, that's the restoration. However, here the imprisonment is not there, but when the license will be cancelled, so it will impact the business of the employer or the organization, and secondly it will impact their finance, and when the business will be impacted, so it will impact their image among their competitor, among their similar labor of the businesses. So that's why the existing labor law have the biggest pain for the organization. Similarly, when we have the organization, because there are the law which regulate the working hour, condition and employment in the organization, then there are the other connecting labor law. So that is like when you are engaging any employee in your organization for your businesses and the business established for the generating of profit. When generating the profit, your business is for generating of the profit. So there, who are the actual generator of those profit or that profit for the organization? That are the your asset, the human resources. So they need to be paid with some bonuses, and that is the minimum requirement assigned and assured the minimum bonus for the industrial worker by the law. So that is the payment of bonus act 1965. However, there are not bigger and obligation for the organization, but that is for the facilitation and providing the some financial support and some sharing of the actual profit which is generated by the employer to the actual generator of the employee, that the bonus or the profit of the organization. But there are the condition that there is the minimum amount of bonus prescribed by the law, that you need to be assured the 8.33% of your wages. It is applicable to every industrial establishment, even though factory, but the condition is that where the organization they are engaging more than a 20 number of the employee in their organization, so it will be applicable to them. But for the below than this number, so it will be depend on them, they want to share it or not. But for the more than 100, that the 20 number of the employees, so it is mandatory to them where they need to be shared their profit part in the form of bonus minimum 8.33% of the wages. And if these obligations related to the payment of bonus act not fulfilled by the organization, there are the or the that the employer, so there are the provision of the punishment that lead to the 6 months of imprisonment and fine up to 1,000 rupees. However, fine is not bigger than big money is there, but the imprisonment that will impact their three areas which I have discussed with you: one, their business, their personality image, and also their reputation within the business domain. So let's begin further what we are covering here. And then after there are the minimum bonus you need to be paid to the your employee, but the organization, there are also the concept that, and there are some exemption also for the new incorporated organization. Why I'm said incorporated organization? Because the organization and the representative of the employer who are assuring the compliance in their industries or the establishment, they consider it for the new establishment or the new factories. It is not for that. The exemption is for those which are incorporated, means the newly company existing and incorporated, not the factories. You can understand it from the example, like there is one organization or a one company that have different plants in the one state or as well as in the different states. So that organization has been incorporated in 1996. Okay, now you are going to establish one new establishment or a factory in a one state in the year of 2022, and you are starting or commencing the business in that. So it is now the question, does the bonus act is applicable to them? Yes, of course, because it is the law say for the newly incorporated organization, that organization, the mother organization of that plant, the organization that is not incorporated newly or within the 5 year, so there is the exemption of the 5 year. That 5 year exemption is for the newly incorporated organization, but not for the newly established plant of that any organization which has been incorporated 20 year back. So the minimum bonus applicable will be them too from their existence and the day of their establishment. So similarly, every organization, even that are the shop and commercial establishment, that are the factories, now they are engaging the manforce through the outsourcing, which is known in the corporate term as the outsourced manpower, and somewhere in the factories or the manufacturing setup it is known as the contractual manpower, but the corporate sector it is known as the outsourced manpower. But those manpower have their working condition, they have their employment condition you need to be monitor the working hours for them. So what are the law existing for the monitoring the working hour condition of employment and service to those workforce you are engaging through the third party? So that is under the Contract Labor Regulation and Abolition Act 1970. So there is the certain obligations where the both the parties who are engaging the contractor or the outsource and who are deploying the outsourcing workforce, they need to obtain the certain approvals from the authority. So for the there are the who are engaging, that is known as, that is considered and defined as the principal employer under the Contract Labor Act 1970, and who are deploying that manpower, that is known as the contractor under the Contract Labor Act 1970. So there both the parties, mean the principal employer as well as the contractor, they need to be obtain the license. So in the term of the principal employer, that is called the registration. And then after the contractor, if they are engaged, if they are deploying the 20 plus manpower in the employer location or deploying that at the side of the employer, they need to obtain the license, the contractor license. How that license will be? So that the principal employer who are engaging them, they need to be give them a certificate of engagement, and there it should be defined, specifically prescribed, that this party they are engaging from this day for a period of that particular time, and they are providing such manpower is there. Then they need to be apply for the license and then obtain the license. When these both the main obligations are fulfilled, so that will be granted there the registration for the employer as well as the license for the contract. But mainly the major or principally it is the responsibility of the employer, they need to be assured everything which is defined under the Contract Labor Act 1970. However, the Contract Labor Act 1970 that make the principal employer responsible for assuring of every compliance under the Contract Labor Act 1970. So there you required the registration under that. Then after you need to be facilitate, that is conditioned in that registration, you need to be facilitate the health, welfare and safety measure for the contractor workers. This is the responsibility of the principal employer, because the manpower which are going to be deployed by the contract labor or the contractor at the principal employer's premises, that is the premises of the principal employer, that is their responsibility to assure the three major objective of the Indian labor law. And if these objective which has been prescribed in the every law and net the minimum facility which has been defined, it is similar to the factories, similar to the shop and commercial, so that similar facility you need to be assured for the contract labor worker also. If those facility not assured, that are the punishable obligation for the organization, and that will lead to the 3 months of imprisonment for the employer and fine up to 10,000 rupees, and also cancellation of your registration. So this is also the one of the pain point for the organization. Even you are outsourcing your manpower to diverting your burden, but when that the compliance or the regulation which has been prescribed under the law that are not fulfilled, then reversely it is impacting the their businesses, their finance and their reputation. So that's why in the beginning I've said that the existing labor law are the pain point for the organization for understanding the future perspective of the existing labor laws as well as the new labor code which are going to be implemented soon, that will be based or defined or decided based on the assessing the norms of the existing labor law. However, there are some loopholes so that the organization they are relaxed related to the compliances, because we have some practices adopted where we assure all that compliances on the document but not on the ground. So when you are engaging the different types or the different categories of workmen, in your organization, even that your own role, that is outsourcing, that is casual, so different number of category has been defined there. So that category, now it come to that you need to pay them something, because they are engaged for your organization based on assuring some payment to them. And that payment, what it should be, can it be just for a some money? It is not that, because law is defining the minimum standard of living for the everyone. So that's why there is the regulation under the Minimum Wage Act 1948. It has defined so that every industrial worker, they should be paid with the minimum wages that define or regularize their living standard. So then when we understand there are the major law existing where you require certain approval, it is also conditioned with that. If you doesn't see as of now, you can check out that the registration or the license you have obtained. So there is many instruction provided. There may be the 6 number, 8 number, 20 number, 15, long list of instruction provided. That instruction are for the connected labor law. Like the Minimum Wage Act, this is not the main labor law where you require the certain approvals, but this is the connecting labor law, and it is mandatory for the every organization. You need to be assured the minimum wage which has been defined by the state. And then after, the organization and the representative of the organization who are assuring the minimum wage, somewhere they make the mistake on the assuring of the compliances. That is one thing which you need to be take care. The minimum wage which has been prescribed by the state, that you cannot pay less than that wages or the minimum wage to any worker in your organization. And secondly, that the minimum wage which has been prescribed, you cannot bifurcate them in the different components, and which has been defined based on the skill. So there are the structure of the skill which has been defined, that is throughout to pan India. There are the 4 level of the skills, and based on that the minimum wage is defined, so that you need to be pay them. And if you are not assuring that minimum payment or the minimum wage to the workman you are engaging in your organization, that will lead to the employer 6 months of imprisonment and fine up to 1,000 rupees. Again, it is the pain point for the organization. And if the imprisonment will happen to the employer, so what will be happen? It will impact their businesses, impact their finance also. They need to be pay some fine also, and they need to be go for the, if that is the 6 month, then they need to be go for the court for the bail. Then it is also impacted the financially and their reputation in their business or their competitor. So it will be biggest challenge as well as the impact for the employer as well as their businesses. So similarly, when it is defined that they required the minimum wage, when that minimum wage required to be paid to them, can the organization pay them for within 6 months, or that can be by annually, or can buy it daily, or can buy it the 15 within the fortnight or within the 1 month. So for that there are the regulation defined under the Payment of Wage Act 1936. However, it was defined before the independence of India. Still it are there, and there are the many amendments happen, but there are the mainly certain 3 and 4 obligations for the employer which are required to be implemented or assured by the employer. So that are the first, whatever the due amount is payable to any individual worker, even that is your direct employee, even that is your outsourced, that is the casual, whatever the category of employee or the workman you are engaging, whatever is their amount payable to them, it is the responsibility of the employer that you need to be assured them. Now, when it is defined that you means the organization, they need to pay the minimum amount for their employee whom they are engaging for rendering the service in the organization for their businesses. So that amount, how you have to pay to them, There are also the regulation which has been prescribed under the Payment of Wage Act 1936. So that is the first responsibility of the principal employer, assure the every single amount or penny which is payable to any individual worker, that you need to be assured and that need to be paid to that person to whom it is payable. And second, then you need to be define or you need to be fix the wage period that you are going to make the payment to the employee who are working in your organization and who have been exit from your organization. So what is that? As per the law, so there are defined some regulation for that. Even though the in the organization, if there are below than 1000 number of employee you are engaging, so there you need to be assured the payment before 7th of the preceding month. Who are engaging more than 1000 number of employee, so that is the payment you need to be assured by the 10th of the preceding month or the next month. And for the exit member, so it should not be more than 30 days. However, it is that their full and final settlement you need to be assured within the 2 working days. So this concept which I am sharing here, you may be heard about when the new codes will be their concept will be come out. So this type of news was spreading that the every individual they need to the individual that you need to be assured to the employee, and that is by the employer or the principal employer, specifically in the case of the contract labor. So it is the responsibility of the principal employer to assure even that the payment is payable to the contractor level also, so that you need to be assured for every individual workman, even that is the direct, that is indirect, that is contractual, that is outsourced, whatever the name you have given to them, so that you need to be assured it. And further, there you need to be assured the deduction from their wages. So the law is prescribing that there you can only deduct up till 75% of the wages earned by an individual employee in your organization for the wage period. That is divided in the 2 criteria. One is with the statutory deduction and without statutory deduction. If it is without statutory deduction, that should be up to 50% only, not more than that. And with the statutory, it should be up to 75%. If these obligations which has been prescribed in the regulation of the Payment of Wage Act not fulfilled by the employer, so there is the provision of 1 month of imprisonment and fine up to 1000 rupees to the employer. Then when you are engaging the employee, so it is the perspective of that engaging of the employee for the long term. Of the perspective you are engaging any employee, they will be the long term asset for your organization, and when you are training them so that they can deliver their potential and their services to the organization for the long term. But when you are expected or you are expecting from the individual employee they will serve you for long term, so in that case, in the reverse, you need to be pay them something or you need to be reward them for their long services. However, in the history, there when it is expecting by the employer that the every individual employee who have been joined to them, they should serve them for the long term, but they did not paid for that as a reward, you can say also, and they are joining for the long term and they are serving the organization, but the organization did not pay to them anything. So assuring that perspective as well as the assuring of their perspective to paying or rewarding them employees who are rendering their services to the organization for the long term. So in the 1972, the government has enacted the Payment of Gratuity Act 1972. So that gratuity is also known as the long service reward to the employees or the workmen of the organization by the organization. And there is one important thing which you need to be know. Gratuity is the one and the only law which define the gratuity as the statutory right of the employee whom you are engaging in the organization. It means when the organization, any employee join the organization, so they provide they means the Gratuity Act 1972, they provide the right to that claim the gratuity, but it has been defined there should be a certain period of services. So it is for minimum 5 years of services required to be into the organization to claiming gratuity from the employer. So there you may have the question also, but exactly when we, any person who, or any worker or any employee who are engaged by the organization, when they can claim the gratuity from the employer, is it exactly 5 years, and what is the formulation for the calculation? So however, the law or the Gratuity Act does not say it about how you have to reach to that level when employee can become eligible for claiming of the gratuity. But one judgment of the Supreme Court that defining the actual calculation criteria for the eligibility of the claiming of gratuity. So that is the 4 complete years and 240 days of the 5th year. If that has been served the organization, that will, the individual person will become eligible for claiming of the gratuity from the employer. So what is that 240 days? Does it the 240 day of actual working they have to be physically there, or otherwise some condition is something else? So the condition is specifically when you have paid any individual employee, even that their weekly off, their holidays, even that maternity leave, whatever is there, when you have paid them for the 240 days, so that individual employee will become eligible for the gratuity and you need to be paid to them. So that's why you need to be assured the every individual people who is in your organization what is their service period, and you need to be keep the track record of that. And separately the people who has been exit, you need to be assured if what is their service period when they have left, and if they have left beyond serving the or rendering the services more than 5 years, does the organization have paid gratuity to them or not? These are the major obligation under the Gratuity Act, and that is the one act which give the statutory right to the workman or the worker claim the gratuity. If these obligations are not fulfilled, that are considered as the punishable offenses, and that will lead to the 1 year of imprisonment for the employer and fine with the imprisonment also. So then these are the different types of the existing labor law that are assuring the some perspective that the employer, when the employer is expecting from the employee, they need to be deliver what they are expecting. In reverse of that, they need to be serve something to them and reward something to them so that the employee can be motivated, so that they can render their services to the organization for generating their profit. Then similarly, when the individual workmen working in the industries, or specifically the industrial labor or workmen, when they are working in the organization, so there are the regulation also provided when they will not be capable to earn money, or when they will be get retired, what will be happen after that, or even that the workmen whom are engaging in the organization, if there are some circumstances happen, and how that circumstances they can face, does there something is available which help them in such circumstances. So for that there are the law which regulate and define the social securities, and there are basically the law which regulate and define the social security, and that is the EPFO as well as the ESIC. So EPFO is also known as the retirement law for the benefit of the retirement. However, it is when we see the obligation which is required, which need to be fulfilled by the organization, so that is specifically every organization that need to be registered under the Employee Provident Fund and Miscellaneous Provision Act when there are 10 or more employee in any organization. And secondly, which you need to be take care as an employer, which is a obligation to the employer under the EPFO, the every employee who you have engaged do you need to be recover and remittance the contribution to the organization. And secondly, that contribution will be deducting on the prescribed wages of the EPFO board or the trust or the member of the trust who will be define it the minimum ceiling for the EPFO, and that ceiling it need to be assured. But second thing is that which you require to be assured, you cannot reduce the wages on what wages you have already started deducting the contribution. If these obligations are not fulfilled, so there it will be lead for the 1 year of imprisonment to the employer and then fine up to 5,000 rupees or otherwise both. Similarly, when the EPFO is the retirement benefit or the retirement security and benefit provided for the industrial worker, and during the employment, if the individual workman industrial diseases, that industrial health issues, so how they can be help and cure their health and their needs, and if the person or any person demise during the employment, so what will be happen, what will be the support to their that dependent, their family members. So for that there is the ESIC Act 1948, which provide the services and the benefit to the industrial workmen in case of their health and then dependency, the pension scheme and the disablement. Such types of the benefit it is providing. There are the 6 to 7 number of the different types of the benefit which facilitated and required to be assured, which facilitated under the ESIC Act 1948. But for that there the employer need to assure some obligation. So that is the for every individual which is in within the limit, prescribed limit and ceiling of the ESIC, that is 21,000, they need to be covered with the ESIC. So for that the every organization who are engaging 10 or more employee, they need to be covered under the ESIC. You need to obtain the restoration under the ESIC Act. Then further, similarly, the reduction, recovery and remittance is the responsibility of the employer, and that you need to be assured. And all the employee who are in the capping as well as the ceiling range of 21,000, that need to be assured under the ESIC Act. And in the first instant, ESIC Act is making and assuring, making responsible the principal employer to paying the contribution in the first instant, even that they are the for contractor also. It is the responsibility of the principal employer that the contribution for the ESIC, it need to be assured by the principal employer. If those obligations are not fulfilled, so there is the provision of 3 years of imprisonment and fine up to 10,000 rupees under the Employee State Insurance Act 1948. Then there are the law specifically when you are engaging the employment or the worker in the industries, so that employee, how you define their condition of services, and then their how they need to be behave in the organization when they are rendering their services. So for that there is the regulation which has been prescribed in the Industrial Employment Standing Order Act 1946. However, this act is for specifically for the factories where there are the 100 number plus 100 or more number of employee you are engaging, you require to be certified standing order for your organization if the condition you are changing for employment condition and code of conduct. However, there is the model standing order available that you need to be implement, and the condition of that code of conduct as well as the standing order you need to implement in the organization. Fourth, one thing, every organization, maybe in the organization you are working, so that organization, they are providing the appointment letter to every individual employee you are engaging in your, or you are employing in your organization when they join. So that appointment letter is the agreement document between the employer and employee. In certain condition you have to render your services in the organization. For that the employer will pay you that much money. See, if that your appointment is well drafted with the regulation of the law. So majorly whatever is there in your appointment, ideally there the if the legal vetted appointment letter is there, there will be 27 number of the different clauses which required in your appointment letter, that is derived from the industrial employment standing order, that is the model standing order there, where the every condition of the services has been mentioned. If these condition not available in your appointment, if that is not factory, that is the other shop and commercial establishment also, so you need to be refer that, and you need to be restructured your appointment letter the condition according to the law, otherwise it will be the obligation for you when there will be any inspection happen. And if these obligations are not fulfilled, so there are the provision of the fine under the Standing Order Act 1946 to the employer. And after that, there are the one of the new regulation enacted, and which is specifically regulating the prohibitiveness in the organization. So in the 2013 there something happened in the outer society, so that's why the government enacted for the security safety of the women worker in the workplace. So there was the POSH Act 2013 was enacted. So that is the new enactment, and that is the major obligation now for the employer which required to be fulfilled by the every organization. There are the 10 or more employee in your organization, so you need to be constitute the internal complaint committee, even though there are no female worker in your organization, but you need to constitute the internal complaint committee. Then you need to be frame the policy for that, where that the prohibition and prevention of redressal of sexual harassment of women at workplace prohibited in your organization. So it is not for only the you are employing the woman, however any customer, any visitor as a female customer come to your organization, that can also complain in the ICC and in the outside also. So that's why you need to assure the POSH Act in your organization and the constitute of the internal complaint committee. Then the order of the constitution of the IC committee along with their detail of the member there and on the notice board you need to be display. So now it come to the question that what should be the structure of the IC committee. So however in the top there can be the many number, but ideally there should be 3 number of the member available in the IC committee. So one should be out of those 3 member, one should be outside, one he can be from NGO or otherwise he has certified POSH practitioner. So you can engage them in your organization for the implementation of the POSH Act or the POSH Act 2013. So what are the penal consequences come to the IC committee that case which found guilty of any individual person in the sexual harassment of the women at workplace, that need to be displayed. And then further you need to be assured the periodical adequate training of those members who are the member of the IC committee. Then further awareness or the sensitization program to the every individual employee of the organization, you need to be assured that. Then further submission of the annual report. However, the controlling authority under the POSH Act 2013 is the district officer or the district officer, so that you need to be submit the annual report to the district officer. Then the employer, they need to be assured the necessary facility and assistance to the IC committee for implementation of any order which they have been recommended. And if these obligations are not fulfilled by the employer, so there is the provision of the 1 lakh rupees fine and the cancellation of the business license, even that is the factory license, that is the shop and commercial establishment, the registration of under the shop and commercial, and any other establishment where they are registered which is providing them the license to commence their business, that can be cancelled if these obligations are not fulfilled. So these are the different existing labor law where it is the many obligations which are the biggest issue and bigger pain point for the organization. They need to be assured by the representative or the people who are appointed and as the representative to assuring all the norms in the organization. But there are the reality also. The irony is that the people who are appointed and represented for the assuring of the compliances in the 90% of the organization, they consider it just a paperwork. And there are the bad practices which has been adopted by the organization to giving something, some packet, some under table, so that in the black and white that records are maintained and the compliance is maintained. But further, when there are the inspection happen, during that time, your compliances which you assure through paying something or assuring your employer it is compliant fully, that will be totally zero and messed up for you organization. So there, the person who is responsible for that, he will be kicked out by the organization, and the pain will be also become bigger for the organization in such cases. So this is the nerve of the existing labor law. However, there may be the many reform will become, but further, till then, we who are the represented for the organization, they cannot assure it, they have to assure it, and they can counter with the agencies for that the regulation they have been, which has been prescribed in the law, they are assuring it as accordingly. Till then, it will be in the same norm, and it will be remain the pain point for the organization. So next, so now these are the existing labor law, and further in the 2017, so there the new government they initiated some labor reform for the industries, so that making it ease of business in the name of ease of business. So they are assuring some reform in the compliances. So in this same sequence, in the 2017 and after that 2019, the concept come out on the name of different labor codes. So there you are well aware about, there are the 4 new labor code which has been enacted in 2019 and onward, 19 and 20, but still they are pending for the implementation. However, these 4 new codes are not new, or there are not a bigger thing new, that are the merger of the existing labor law. So that's why when we have to understand the future perspective of the Indian labor law, still it is going to be changed. However, there are the changes happen. What are the changes? So I'm here sharing with you what are the changing happen and how it is impacting to the industries, as well as the career of the people who are responsible for assuring the compliance in the industries. And that's why in the beginning I have also said, in this program we will prepare you and make you ready for those implementation. But what you are learning today, you need to be learn that, practice that in your organization and implement that, so that you can assure that your organization is fully prepared for the implementation of these laws. It is not now so far then when it will be announced that the laws are implemented from this date. So from the new financial year, from the 1st April 2022, it is possible those law will be implemented. So what are these 4 new codes exactly? So which is given the name specifically, it has been that arranged the different existing labor law in the one platform, and the similar labor law which regulate the one type of the norms in the organization. So for understand that, the first code, which is the biggest in the news, and maybe we all are aware, there are the new thing, new concept has been 12, that is the code on wage 2019. So what is new in that code, and what is the old in that code, and what is exactly this code? This code is not nothing. That is the merger of the 4 new existing labor code or the labor act, which regulate and monitor, define the wages, even that is the minimum wages, payment of wages, bonus, and equal remuneration. And similarly, there is the new code which has been enacted on the name of Industrial Relation Code 2020. So that code is not something new. Some condition has been removed, some condition has been added in that, but exactly that is also the another platform for the existing labor law which regulate the industrial relation, monitor the industrial relation, and define the industrial relation in the organization. So that are the Industrial Employment Standing Order, then the Industrial Dispute Act 1947, Weekly Holiday Act 1942, and the Trade Union Act. These are the existing law already available. So we have discussed in the previous section on the beginning of, in the first section in the beginning, so there the 10 number of the existing labor law, and that is specifically the panning nerve for the organization. And then the new codes, what would you expect from that? That will be really the industrial reforms that will really help the organization ease of business, or that are something else. So continue with this session, you will be get all that things here, what exactly that laws which are going to be implemented soon impacting the organization and how. Then similarly there is the another code, that is Occupational Safety, Health and Working Condition Code 2020, and that is, there is also nothing new. So what have happened or what have we done there? So that is the another platform or another plate on the table has been served, that whatever the cookies available, so just that has been transferred to the one plate, one bucket, and then little bit of the good thing has been added and something has been removed, and then after it has been served as the Occupational Safety, Health and the Working Condition Code 2020. So it is the merger of the 8 to 9 existing labor law or the Labor Act which regulate the occupational safety, health and working condition. However, exactly the working hours, condition of employment and services in the industry, so that are the all existing law has been merged under this act. So what are those? The Factories Act 1948, the Mines Act 1952, which regulate the working hour, condition of services in the mine. Then Dock Worker Safety, Health and Welfare Act 1982. What is that? That is regulating the working hour, condition of employment and services in the mines or the dock. Then there are the Building and Other Construction Worker, that's the Regulation of Employment and Condition of Services Act 1996. What is that? That act is simply regulating the hours, condition of employment and services in the building and other construction work. Then the Contract Labor Act, so that is the law specifically regulating the hours of working, condition of employment and services for the contract labor when they are engaging by the principal employer. And there are the separately the Sale Promotion Employee, Interstate Migrant Workmen. So these are the existing labor law which has been merged in the Occupational Safety, Health and Working Condition Code 2020. And the last one, there is the new code, the Social Security Code 2020. It is not a new also. So in that cause, in that new, the Social Security Code 2020, what the government has done, so that are only the existing labor law which regulate, define and monitor the social security. Just we have understand in the previous section there the EPFO, the ESIC, the gratuity, so that are defining, regulating and the monitoring this social security in the organization for the industrial worker, and the minimum social security norm that has been provided, so that has been merged in the new Social Security Code 2020. The Employee Compensation Act 1923, the Employee State Insurance Act 1948, then the Employee Provident Fund and Miscellaneous Provision Act 1952, and the Maternity Benefit Act 1961. However, there are nothing changed for that. The same has been merged in that. One condition has been applied that, and separately one chapter has been filled up with the same condition. There is nothing new, but there is something impactful for the organization. I will share it in later. So then is the Building and Other Construction Work and the Employment Exchange. So that are the existing labor law which has been merged with the new Social Security Code 2020. However, during the 2070, however, when the second period of this new government was started, so then they have introduced these labor law reforms, and the 29 of the existing Central Act that has been merged under the 4 new codes. So this is the total scenario of the existing labor law as well as the four new codes which are going to be implemented soon. But the changes are there. Somewhere, if you see from the front, so it will be see that it has the reforms for the organization. So let's check out that. So just see this slide. Is this slide visible to all of you? This is one of, so what you can consider from this. So it is, you can see there are really some reforms happen after these four new codes are going to be implemented. Yeah, exactly. We can say that it is certain reforms also, because when the compliance part has been considered as the paperwork, and that paperwork in the existing law, that is the too much, which the people who are responsible for the compliance, they are not considering that much productive work. So that's why the compliance does not consider as the good job for in the organization. And if we see what will be the change in the front side of the, which is considered as the biggest reform for the organization. So from the slide you can have the overview that there are really some reforms are happening when these four new codes are going to be changed. However, there are some reforms are also available where you have to maintain certain documents that the numbers only reduced. Like as per the existing labor law which are applicable to any industry, majorly we are that the exemplifying the factories. So there are around 40 number of the certain register and records you require to be maintained. But when these four new codes will be implemented, so there will be only 11 records you require to be maintained. And secondly, when you have to submit that you have obtained the approval, then after there are the condition you need to be facilitated in that, then that you need to be submit the regular or the periodical status of the those implementation of those regulation in the form of the returns. So as per the existing labor law, there are the 22 number of the different returns under the different existing labor law we are submitting to the authorities. But when these four new codes will be implemented, there will be only four return you require to submit it. But it is not mentioned that it will be consolidated. However, the information as of now we are sharing with the 22 different returns that need that same information you need to share with these four returns or the four in the periodical return under the different four new codes. Similarly, it come to the different license you require to obtain. So as per the existing, so there are the two license you require to obtain. So when these new codes will be implemented, so there will be the license number will be increased. And then the different types of the display which require to be displayed by the organization, where the applicable labor law are, which are the applicable labor law to the organization, their abstract, their under the different notices under those law you require to be display at your organization some conspicuous place. But when these four new codes will be implemented, so that however the number will be reduced somewhat, because in these new codes there are the some abstract has been clubbing with the one and another. So that's why you need to be display the 30 number of the different documents at your organization at a conspicuous place. So mostly as per the compliance it is considered as the entry gate, so that you need to be assured the 30 number of the display in your organization. Then it come to the registration. However, as of now there are the 5 number of the registration which required for an organization, but when these 4 new codes will be implemented, there will be only 3 registration the employer need to obtain. Then the next one is the remittance. So it will be remain same. Here in with the existing labor law, we are remitting the contribution under the 2 Social Security Act, that is the EPFO and ESIC. That will be remain same, where you have to remittance the contribution to the those 2 organizations which is securing the social security for the employees. So Now the exact turning point for the labor law, which is going to be impact the industries tremendously. So just have a look on this slide. The slide is visible to all of you. So just look on the slide. So what is going to be happen? So there are the 4 and 5 types of the existing labor laws or the existing labor act which are merged, which has been merged under the Code on Wage 2019. So there are the certain obligations which has been defined as punishable for the organization when those regulations not fulfilled by the organization. What will be happen? So that is the punishable, and under that punishment, so there are the provision of the fine as well as the imprisonment. So if we see the all four act which has been merged under the Wage Code 2020, so that is the fine and imprisonment. So there is the minimum fine as per the existing labor act that will be imposed to the employer for any obligation which is not fulfilled, minimum 500 rupees and maximum 20,000 rupees, and the imprisonment that will be minimum 1 month and maximum 6 months. And when the new code on wage 2019 will be implemented, what is going to be happen? That the fine which will be imposed minimum 500 rupees and maximum 20,000 rupees, it will be changed. Minimum that can be imposed for 20,000 rupees and maximum 50,000 rupees for a small non-fulfilled obligations. So now think, if there are under the code and wage, so there are like 5 number of the obligations which are not fulfilled or minor fulfilled, or that is considered as the non-conformity and the non-fulfilled compliance. And in that case, now there are the 5 number of the non-conformity imposed to the employer. So the actual impact of the finance for the employer, what it will be? It will cost near about 2,50,000 rupees under the Code on Wage 2019. And similarly, let's understand, however, the imprisonment under the Code on Wage that has been removed the condition of imprisonment under the Wage on Code Act 2019. Similarly, just see the Industrial Relation Code 2020. There are the existing labor law which has been merged under the Industrial Code 2020. So there is the provision of the fine minimum 100 rupees and maximum 5,000 rupees, and imprisonment is not there. But when the new code, the Industrial Relation Code 2020 will be implemented, so there the fine which will be imposed for a single non-conformity and non-fulfillment of any obligation, that will be imposed minimum 50,000 rupees and a maximum 2 lakh rupees. Now just example, just imagine if there are 5 number of, even there, if you have seen the inspection, so in the throughout the inspection there will not be in the organization, if the organization they consider that that is fully compliant, they will also have the non-conformity average 30 numbers. It is not just an example, it is exactly we have worked with the organization where we have seen average number of the minimum, that is the minimum 30 number of the non-conformity will be there. And for example, if it will be 5 number of the non-conformity under the Industrial Dispute Act, so what will be happen? When there is the 2 lakh rupees fine can be imposed for the one single income, that is the non-conformity or the non-fulfillment of the obligation, it will be lead to the 10 lakh rupees cost. And 10 lakh rupees is the annual salary of a HR manager or the assistant manager. However, it is for the bigger organization, but in the mid level of organization, it is the managerial salary 10 lakh rupees. That is too much. So it will be cost to an employer just in one non-compliance. And there is also the imprisonment condition has been incorporated in the Industrial Relation Code 2020. So that is the 1 year of the imprisonment too. And similarly, these two codes which we have discussed, the wage code 1920 as well as the industrial relation code 2020, there is the social security code 2020. So there are the 7 to 8 number of the existing labor law which has been merged under the code on social security 2020. So if we see with the existing labor law, what is the condition or what are the punishment prescribed? So there, if any non-conformity happen in the organization and there are the minimum or any non-compliance or the non-fulfillment of the obligation, so minimum fine which can be imposed under the existing labor law, so that is 500 rupees and maximum it is 20,000 rupees, and imprisonment is minimum 3 months and maximum 3 years. So now when this new code will be implemented, what is going to be happen in condition of the code on social security 2020? So the fine which is a minimum 500 rupees for the existing labor law, that will be increased for the 50,000 rupees minimum, and maximum it will be go up till or 1 lakh rupees. And now similarly, just example the 5 number of the cases and the non-conformity happen, so there will be the in one inspection 5 lakh rupees immediate cost to the employer, and then after there the imprisonment that has been increased minimum 3 month to the 6 month and maximum 3 years. And then it come to the code on the occupational safety health and working condition code 2020. So there are the different existing labor law which regulate define the working hour condition, occupational safety health and working condition in the organization, that has been merged under the code on occupational safety health and working condition. So if you see, there are the existing labor law, there is nothing new, but the existing labor law has been merged with the one platform, and that name has been given the occupational safety health and working condition code 2020. So under this code or the existing code which has been merged under the existing act which has been merged under the new code on the occupational safety health, so there is the minimum fine which can be imposed to an employer 500 rupees and maximum 1 lakh rupees, and imprisonment that is the minimum 3 months and maximum 2 years. When this new code on the occupational safety health and working condition 2020 will be implemented, so the fine for any single non-conformity or the non-fulfillment of any obligation, that will be imposed to the employer minimum 50,000 rupees and maximum 5 lakh rupees. Now again, just imagine if there are the 5 number of the non-conformity and the non-obligation, the fulfillment of the obligations in the organization under the new code on occupational safety health and working condition, so it will be cost to the employer 25 lakh rupees. A general manager level person's salary of a person in the one just inspection or the non-conformity, 5 number of the non-conformity which are not compliant as per the norm prescribed in the new code. So this is all about the 4 new codes, what is going to be happen, and that are really somewhere in the documentation that are the reforms, but that reforms will impact the organization tremendously and financially majorly. And however, the practices which the organization have adopted under the table, that can also not be possible. Otherwise, you have to pay equal money to the inspector, where you are paying just 5,000, 2,000 rupees. Then he will have imposed 25 lakh rupees. Can the organization pay 25 lakh rupees to them? Never. They will kick out if you talk to your employment that you have to pay as a bribe to the inspector as 25 lakh rupees. So what is the solution? So solution, you have to develop the solution. So the same solution we are learning here today, how you can assure such financial losses to the organization, and how you can transform these, which are the bigger or pain point for the organization, as your unique selling proposition for your professional success in the organization. However, before going into learning the practical session and developing of the system for assuring the compliance in your organization and making you prepared and fully ready for the future before these new codes will be implemented, so there we have one representation for you, and there we have evaluated all that laws what are coming and what come out there, where we can consider it the some reform for the labor laws, and then the different condition which has been incorporated in the new laws or the new codes, how you have to prepare for that. So further, one which can say that the reforms are there. So in the specifically the definition of wage, as per the existing labor law, there are the 16 different types of definition provided for the wage. But when in the new code, the code on wage, there is the concept of the wage provided. That concept will be considered equally to all the four codes. So that's why that we can say that that is the one of the bigger reform, where the wage has been defined common to all the new four codes. It will be considered same. So the wage definition will be the basic pay, then dearness allowances, and the retirement. This is the definition of your wage, where the basic pay you have to pay with and the dearness allowances, then the returning allowances which you are paying to them. And there is one new concept, that the wage which is defined for the law as per the new code, that is the where the wages you are paying to them, the basic pay should be 50% of that wage you are paying to them. So as per the law, the wage is the gross wage you are paying to any employee in a monthly basis. When this concept will be implemented, so we have seen it will be impact both the employer and employee. How? So it will be impact both the employer and employee financially. It will increase the cost for the employer and the reduce the take home salary for the employee, when the basic wage will be 50% of the gross wage. Then after there, the new reform, which we can say as a reform, the separate definition for the worker and the employee has been given. However, as per the existing law, there was no definition for the employee. So as the corporate concept, there was the blue collar and the white collar, and the everyone considered under the law as worker. But now with the new code, it has been divided separately, the worker definition, which is known as workman, and the employee, who are the manager, that is supervisory, and the staff role, they are considered as the employee. Then there is the new concept which has been developed, the floor wage concept. Based on that, the minimum wage will be defined by the state specific, and that floor wage will be based on the region and the certain criteria like the urban, semi-urban, and rural. And that concept of the and that floor wage will be revised every 5 years. Then there is the definition for the contractor, and contract labor has been defined also. Provision for related to the period of payment, that has been revised, and some reform has been given there. So reform are that earlier, as per the Payment of Wage Act, where there are the defined as per the number that the wage you can pay by the 7th for the below than 1000 number, and by the 10th of the next month for the pay period, previous pay period, that is the 10th, if the number of employee are more than 1000. But in the new code, that has been made equal to all. Before the 7th, you need to be assured the every payment of the. And then we have discussed also in the previous that nerves of the existing law. So there is the standing order. The provision is that every organization, you have the 100 or more workmen, you need to be certified the standing order for your organization. That number has been revised for 300. And there it has been assured that the every organization related to the that any grievance happen, that will become further the biggest industrial issue. So for that, every organization, they need to be constitute the redressal committee for every 20 or more workmen you are engaging. Then provision of the aggregator has been incorporated in that, and the period for the claiming of gratuity as well as the becoming eligible for the gratuity, that has been reduced for the 3 years. However, the gratuity is still the right, statutory right of the employee. Then there are the another implementation, and the incorporation has been incorporated, or the concept has been incorporated, or the regulation has been incorporated, that is related to the free annual health checkup for every employee by the employer free of cost. This is mandatory concept. Then after, related to the leave, there is the new concept has been added in the new code, that is the, as of now there are the majorly 3 types of leave available in the organization. One is the privilege leave, which is paid and provided based on the working, and then there are the another leaves, which is the casual leave for the casual work of any industrial worker, and the sick leave for the sick reason. So earlier, mostly the organization, and there was no condition for that, if the employee does not avail the casual and sick leave, that will be lapse for the year. But the new condition added in the new code, that is specifically the leave that can be carried forward and accumulated till 30 now, and the privilege leave that can be carried forward and as well as accumulated for the unlimited time and the unlimited number. Then there are the incorporated the two another concept, that is the employment of the women beyond 7 p.m. before 6 a.m. has been accepted, and further the organization, they need to be facilitate their through and fro with the security. And then for the, if you are engaging any employee of your organization on overtime, you need to take their consent first, then you can allow them for the overtime. So these are the different types of the reforms when we have evaluate all that existing four laws that come into the picture. But majorly when it come to the practical basis, so first of all, the bigger concept is that is the wage. Wage is the one of the only point which define your industrialization in the organization. So that's why you need to be ready for that. You have to change the concept of your wage, you have to restructure your wage when these 4 new codes will be implemented. So we have prepared one scenario for you, that what you need to be do in the case of when you have to restructure your wage, what will be the actual financial impact due to the concept of the basic pay 50% of the gross wage has. Exactly what is happening when this new concept of the wage or basic wage will be implemented. So just okay, break just after 5 minutes. We are just covering this section. So if you want to be break, so just now we are going to be break. Okay, so it is the 6:12 now, so we will take the 7 minute of break. So 6:19 we will be back all. So before that, also prepare your some question. I will ask you some question, so you need to be that answer in the chat box. So there is the 6:12 and sharp 6:19 we will be meet again. So it is the 7 minute of sharp break. So just take your water, UT, whatever you want in the 7 minutes. Then we will be meet by 6:19. Basic wage, and that basic wage every calculation will be done. So as per the existing law, as we have discussed, that the minimum wage cannot be bifurcated, and it is made strictly with the new laws or the new code specifically. So as of now, the minimum wage which is notified by the government, specifically the state government, so that has the certain particular and a component. One is the basic wage and second one is the DNS allowances. However, for the basic wage, this is the whole amount defined as the basic wage and the minimum wage. So as per the minimum wage act, you cannot bifurcate that wages in the different component which has been prescribed. So that is the internal term, but it is not defined. When the government announce the minimum wage, that will be this equal amount, where some part of the DA will be added in that. Exactly what is happening, the minimum wage which revised in every 6 months, that is not exactly the minimum wage, that is only the dearness allowances which revised by the state government based on the inflation change or index of the inflation change in their state specific. And further, if you know or either not know, you will be shocked that the minimum wage concept, which has been or which is conceptualizing and which is considered in the 2021 also, that is started, and that is based on the 1991. And if you see the calculation base for that, so the inflation has been increased from that 340 times from the 1991. 1991 is the year when the India adopted the capitalization. Okay, this is the another topic, but here we are just discussing about the what you have to assure, how you have to, when the new codes will be implemented, how and what you have to do when you have to restructure your minimum wage. So accordingly, there are the different types of the contribution you have to make, which is specifically the biggest obligation for the employer, and every or any issue or related to the industrial dispute that are based on the wage as well as the contribution happen. So if we see in the scenario of the provident fund, so as per the existing norm, and there are the contribution capping for 15,000. In that case, if the wage is less than that, you need to calculate, or you are calculating the contribution on the basic wage. For example, if in any state the minimum wage is 8,000 rupees and you are total paying 12,000 rupees to the workmen, so in that case there is a capping was 15,000 rupees, so you need to be pay the contribution of the 960 rupees. And but when the scenario, and you have to pay it for the basic wage only, but when the scenario it has been changed for the 50% and that the minimum wage, however exactly it cannot be bifurcated, and the concept for the 15,000 that is available and which is going already it is existing, so that you need to be pay the 1440,000 rupees contribution for the EPFO. Secondly, in the scenario number 2, where you are paying the gross wage to any employee 20,000 rupees, in that case the capping is 15,000 rupees and you have to deduct the contribution of the 15,000 rupees. It is costing for you the 1800 rupees for the employer part, and similarly part you will be deduct from the employee. But further, when this concept of the wage or 50% of the wage will be implemented, or the minimum wage cannot be bifurcated, and that you need to keep as the basic wage, so that you need to be paid the 1440 rupees. Then there is the relaxation for the employer. It is not impact. When there the lower will be the wages, impact will be high, but when the wages will be increased, so that impact will be lower. And similarly, if the scenario C, there you are paying to anyone the 24,000 rupees and the concept is the 50% of the basic wage of the total salary, so it will be 12,000 rupees, and similarly the calculation contribution for the EPFO will be remain same, 1440 rupees instead of the 1800 rupees. And if you are engaging the international worker in your organization, so in that case the your contribution which you are paying as of now, for that is on the full wage what you are paying, but that will be revised or reduced for the half of the amount. So that will be based on their basic wage, and that should be the 50% of the whatever the wages you are paying to them. Similarly, in the case of a gratuity, what will be happen as per the existing Gratuity Act 1972? So gratuity will be calculated based on the basic wage or the basic salary. So that is the formulation is specifically the 15 days considered, then the year of the working, however what any year they have the employee have been served, then that will be divided by the 15. So as per this formula, basic wages, which is for example the 12,500 rupees, it will be cost 72,115 rupees to an employee for the 10 year of the services. But when the new code will be implemented, so when the concept of the wage will be revised, and when you have to incorporate the gratuity in your salary structure and you have to pay that to the employee, so that will be calculated based on the 50% of wage, and that will be cost to you near about 15% addition to the existing calculation. Then in the third scenario, and when there the closure in that the entrenchment closure of the company, the compensation specifically under the industrial relation code and as per the existing norm, it is the compensation, the employee compensation act 1923. So in that case, what is happen, or specifically under the ID act, so it is there the, it is the every calculation of the compensation which is paid for the closure, retrenchment and other cases, that is based on the gross wages. But when the new code will be implemented, so it will be based on the 50% of the wages. So in that case, it will also give the financial relaxation to the employer where your cost will be reduced. But it is in the case if closure. And then the third case, so the minimum wage as per the new code or the code on wage as well as the occupational safety, health and the working condition code. So however, as of now, the basic wage is the minimum wage which has been defined, but in the under the code on the occupational health and safety, the basic wage should be 40, that 50% of your gross wages which you are paying to them. So accordingly, you have to restructure your organization. Similarly, there are the condition for the organization. You have to provide the employee who are coming or under the income tax, so accordingly you have to implement a cost tax friendly structure to your organization. So for that, you have to take the references, so that we have added here it for your understanding and implementation, so that you can easily restructure your organization structure for implementing the new norm or the regulation under the new code. So this is the template which will be reached to you as it is for your learning, understanding and keeping for your personal custody. Related to the section 1 which we have covered as of now, so the section 1 is related to specifically the understanding the pain of the existing labor law and the future perspective and what is happening with that. So we have covered there the assess the nerve of the existing labor law, and those labor law has been merged with the new codes and which are going to be implemented very soon. And for that, you need to be ready for that and you need to be prepared for that. What you have to do that, one thing, you need to be check your structure. So for that, the template I have been shared with you. What you have to do that, you need to consider that template, and this video will be available for you tomorrow, which will be shared with you. So with this template, you can utilize that template for restructuring your salary according to the new law and its implementation, so that you can be prepared for implementation of all the concept and the regulation which has been prescribed under the existing labor law. So further, now come to the section second. So section second is specifically to, now it is the going to be how you have to be prepared when these new regulation will be implemented and your organization should be ready, so that you can secure your organization. And I have been asked you question in the beginning, what are the 4 qualities of a labor law compliance specialist? So that are the 4 qualities. Specifically, the labor law compliance specialist, they should be vigilant, they should be foresighted, they should be accountable and they should be more responsible. These are the major 4 successfully of the labor law compliance specialist. And when you adopt these skills and develop these skills within you, it will become your unique selling proposition for your career progression. And second, when these 4 new codes are going to be implemented, the labor law compliance portion, that the implementation of its norm and regulation that you have to comply with, it is going to be a growing sector and is the growing profession for the HR people, the labor law specifically. However, as of now, in the mostly the organization who are the people responsible for the IR and the strategic role, they have been paid more. Similarly, in the new norm, when it's going to be the next new financial year or next 1 to 3 year, so the labor law will be the major requirement of the professional implementation in the organization, because maximum the strategy that will be automated, so that will be done by the system, but your IR, your compliance cannot be done never by the system. You need the people for that, and that will be you are learning this concept to a day, and the practical concept or system which I'm sharing with you now. So let's begin, and its impact on the industry as well as the career of the HR, your preparedness and readiness for the future. So let's begin with, so many member has been left, so no issue. So with the member who are available, so we will try to implement this concept, and then you have to implement it in your organization. All that document or templates which I'm sharing it here with you, that you will be get as same it is for your organization as well as for your personal custody and implementation. So in the second practical or the second section of this program, we are going to develop a level of compliance management portfolio, how you can be ready for the future, as well as you can also assess your current organization based on this system. So first of all, what you have to do, you need to be understand the structure of the regulation and the law, what their structure is, and how that structure will be become that system in your organization, and you can assure every norm and compliance in your organization, so that there cannot be a single non-conformity in your organization, because in the future it is impacting too much on the financial ground to the employer. And however, if you know all those concepts, you can assure the compliance, you will be progress. Otherwise there are the chances to kick out that who will be responsible for the labor law compliance management now, because this is going to be a bigger impact to the financial ground to the employer. And secondly, when you learn this system and implement, it will become the unique selling proposition for you. It will also help you where your succession in the organization, and however in the next level where you want to go, you can create a value branding for yourself, where you can demand whatever the money you want. As of now, the strategic people, they are demanding. So let's begin with this session. So first, in this statutory compliance management portfolio, we design this concept based on the three pillars. So in that three pillar, we are going to discuss first understanding the structure, then the process, and third one, we need to then their reporting, how you have to report. So how you can build your credibility in your organization. As I mentioned in the beginning, why the compliance always failed in the maximum number of the organization. When you present or report it to the management, the people who are in the compliance management, they comply it for the employer, but exactly you need to be comply it for the regulation and norm and the authorities who are monitoring and who are appointed for the monitoring of this. So here I am also sharing with you one tool which will make you capable that you can work one ahead to these agencies, government agencies who are appointed for regulating the labor laws in the industries. And then third, in the third pillar reporting, I'm sharing with you the concept that where you do not have to share that what you have done, your work will automatically report your working and your success as a compliance leader in your organization. The same picture we are building here, and all those template which we are going to implement here, that will be reached to you as it is for your practices at your location, as your home, at your workplace. So now first we need to be understand that the every law, they have the three layer of structure. How it come to the layer of a three layer of the structure? So you can have the question like, there will be the approval, there will be some records you have to maintain, then you have to submit the different return or the periodically. But some law like the minimum wage act, so that you does not require any approval, that are the secondary law and connected law. When for example we are exemplifying the factories, so a factory can be run in a premises when you have a license for that. When you obtain the license, so that will be conditioned with the other law which you have to facilitate in that. So what happened? First, you need to obtain the approval. So there we have the procedure available. You need to be follow up that procedure, and then further, when you obtain the approval under the factories, so in form of the factory license, then you can commence the business in your organization. And further, there are the condition provided where the sporting law, their norm, their regulation, you need to be facilitate, which have been prescribed in that you need to be maintain the record for that, and that record you are maintaining based on the facilitation of the condition that has been given to you and instructed in your approval which you have obtained from the authorities. Then you need to be submit the periodical compliance status. You are complying all those norms in the form of the return. So this is the structure of the labor law compliance. So first, when you understand the labor law based on these three pillars or these three layers, so it will be easy for you to implement. So now, let's go to understand that what is the structure. So here we have prepared one master template for you that will one of the reporting master checklist and the master template for you which you can utilize at your workplace, and that will make you, that is the first one, the four skill I have mentioned with you, the quality, that is the vigilant, foresighted, as well as the accountable and responsible. So this template which I am sharing with you, that will make you the vigilant first, the first skill. Here you are developing of the labor law compliance specialist. So let's begin and understand that what that template will help you and how it will help you and what you have to do in that. But in the structure, it is just the part of the result of all your background. So here, as I am mentioning that this is the particularly as I discussed the structure. So what you have to add up in that, this is the template which you can utilize as it is, just you have to make it changes as per your organization. So there in the first structure, if we consider in the factories, so there are the different types of the approval you require. So that is the factory license, pollution, that consent, no objection certificate under the air and water consent, hazard waste authorization, building plan approval, then fire NOC, EPFO, and the registration under ESIC, registration under the contract labor. Then if that is the premises leased on, that are the document you require to meet, that are the certain approval required under the different applicable labor law. And then what are the location you are maintaining, so their status you can implement it here. So this is just for the one slider or one pager which you can print, and what is their status and your forthgoing activity, what you have to done to comply with these norms, so that you can add up here. So automatically it will become make you the more vigilant what you have to do. And when you have to do what is your next action, so that you can assure everything, because it is considered that that people who are in the labor law compliance, they should be more vigilant. So this template will be make you more vigilant. We have added up as for the factories every compliance which you require to be maintained in your organization as per the act, whatever the act are available there. But in the state, which if you are working in some states, there are the some 1 and 2 only the act, local act, which can be applicable there. Otherwise it is centralized and all you can utilize it for your organization. Then you have to define there the due date. However, it is the due date which has been prescribed by the law, so that due date you need to be fulfilled. Then there you should have a person who will be responsible for that, assigning in that, so that you can assure every compliances. If you require some support for someone, some document you require to arrange from someone, so that you need make the person as responsible. And then the when you have to update, and when that particular due date is there, and what are the action you have to be required for that, so that will be done there. And in this template you will update it accordingly. It will make you the vigilant. And second portion is related to the different types of the display which is required. So as we have discussed, there are the 40 number of display. When the new codes will be implemented, so it will be the 30 numbers. So accordingly, what are the display required and what are their frequency and who will be responsible for that, so that we have been mentioned that it for your easiness and implementation. Then there are the different types of the record which you require to be maintained as per the existing labor law, as per the future, so that you will be all incorporated in this format and you can utilize it as it is. So this is the first template which will make you more vigilant. You have to divide it as per the structure. So structure is specifically what are the approval you require to obtain, and second, what are the record for those approvals you have to maintain. So how it will become, what are the record, so it will become from the instruction provided under that registration which or the approval you have obtained. Then third one, the periodical, whatever the status of the compliance you need to be submit, so that is mentioned here. So accordingly you can easily make it aware that when and what you have to comply with the norms. So this is as the master template, and you can give it the name of the master calendar, which you can display at your desktop, and it will make you more vigilant what is going to happen and what you have to do and when you have to do. That is the first skill that are going to make you more vigilant. So now let's move further with the next one. So next one is related to how you have to reach to this level. This is not just you can implement in your organization if you know, but if you don't know exactly when you have to comply with the every norm, how you can reach to that level, so that is going to be assured with you, and how you can implement process of the reaching to this three layer of structure. You understand the three layer of structure, but when it comes to the part of compliances, so how you have to reach to that three layer of structure, that system which you have to display at the your desktop, which will make you the more vigilant. Then it comes to the second pillar of this level of compliance management portfolio, that is the three layer of compliance process. So we have divided it in the three layer as per the requirement in the organization, and that is the number one where you can implement the internal compliances by itself, and second, that is the agency compliances. Agency compliances mean compliances you are hiring the agency for the assuring the compliance, and secondly you are assuring the compliance for the agencies, like you have the vendor, contractor and other vendors also, because the contract labor act making the principal employer responsible for assuring the all the compliance under the Contract Labor Act 1970. Then third one is specifically when there are the inspection of the government authority. So that is the period defined as per the law, the 3 years. So it is assured that it will be happen. But when the new codes will be implemented, it will be more rigid and it will be frequently implemented. However, you have to practice that under the table when there the inspector they had been made the assured as the aggregator, they need to be guide you first, then they need to be assured the compliance of yours, and that is the one of the biggest challenge for the organization. So that here I am sharing with you one tool and the system how you can work one step ahead to the government agencies, and when they come for the inspection for your organization, you can counter to them. So let's understand the three layer of process how you can reach to them. But here with this master program you are learning, we have specifically designed the formulation for you where you do not have to do much and that collect the data for that. So that information we are providing, you just have to evaluate your organization the current status, then you have to assign that the non-conformity which is available in your organization. For that you need to be start the process which I am sharing here with you. So first understand that what exactly you have to do for your organization. So making sure that you can implement 100% compliance in your organization related to the norms and regulation of the existing labor law as well as for the future too. So it is the one of the master template which we have designed specifically for your understanding and for your implementation, how you can evaluate your organization, what it is required for your organization, and how you can assess the current status and nervous of your organization, are that or is that ready for the future implementation of the new labor codes. So it is here, the screen is visible to all of you. This is one of the template and which is known as a master checklist, which we have prepared for you, and every existing labor law we have incorporated in this template based on their requirement for the perspective of the specifically factories. However, if you are working in the shop act, so there are the 1 and 2 act which you have to change, otherwise will be same. So instead of the factory, you need to be incorporate the shop and commercial establishment act. Then what are the regulation and which rules of the particular act, what it is applicable for your organization, what are the requirements under that as per the government norm and the system which the agencies they have, then what are the references you required, then what is the status, the current status of your organization, that based on this checklist you can evaluate your current organization status of the compliance. Then who is the concerned section, however it is responsible, however in the organization, that are the legal section separately, or otherwise the HR department, they are concerned with the statutory compliance and the labor law compliance. Then it come to the, in the department there are the some person who is responsible for that, and then what is the frequency for that, and what are the next action you required, and whatever the periodically you required you can utilize. Then the further whatever the status, whatever the outcome you get, or the differences USS and the open point USS, so that you can identify that, then decide your next action, and for that who is the responsible person, you can consist with that, assure the responsibility of that person. And this is the one of the template which will make you assure what you have to do in the future, and what is going to be, and what are the rules when there in the every 3 year 5 year the inspection will be happen, so that you can assure your compliance is based on this concept, so that you do not have to become haphazard during the time of the compliance. So mainly in the organization we have seen when there the notice come for the inspection, so that every time the people they are just moving here there and then running behind that, you have to assure that you have to assure this thing. So that's why we have designed this concept where you do not have to run anywhere, you just implement it one time with the systematic way, then never your inspection will not be failed. So this is the second template, and this is designed based on the concept of the developing your second skill as a professional, the making you more foresighted, under which section what is happening, you do not have to go to the referring of the whole book of the labor law. So it has been already done here, it is based on the practically how the inspection done by the labor function. However, in the throughout the India, the function of the labor department are same, that are the equal in all the state. So this template will be reached to you as it is. Then you have to utilize this as a master for evaluating your organization's current status based on the required labor law for your organization. And then when you utilize this template, it will be show with you what are the gap. Then the actual process started, how you have to overcome that gap, and you have to reach with the compliance level, assuring of the 100% compliance level for your organization. So someone is asking that share the same by email. Everything which I am sharing here with you, that will be reached to you as it is. Don't worry, after completion of this master session, so it will be reached to, however it does not, maybe by 7:30 or 8, or otherwise today before the end of this day it will be received to you through mail. So don't worry for that, every document which I am sharing here. And this one person LCC MAST 123 is asking for the that sharing of all the document. It has been committed to you everyone that what we are sharing here, it will be reached to you at is. However, there are the many other templates we have designed supporting documents also, so that will also reach to you, which we are not sharing here. So many documents you will also reach that to you, so that you can implement the concept in your organization. Our purpose is not to hiding something. Our purpose to making you aware and ready for the future and skilling up you for your career succession. And the question is someone asking, would you please share the approval checklist and the compliance three-layer sheet again? So sheet will be reached to you. However, we have to cover the program. So slide I will share one time with you, so that you can make it well fair when you referring the video session by tomorrow, when it will be reached to you, may possibly by 2 or 3 p.m. or by 5 p.m. maximum tomorrow. So you can refer it with the document and validate when you have to learn. So document will be for your personal custody, as well as the video you can also utilize. It will be lifetime access to you, so whenever you require you can utilize that for your learning. So now it is that someone asking the question related to the three layer of the structure. So three layer of structure is specifically based on the whatever the primarily applicable labor law, like for the factories. So primary that the applicable labor law is the Factories Act 1948. However, then after you are engaging the contract labor, so the it will become the Contract Labor Act. So you need to be obtain the approval. Different types of the approval you require to be obtained, so that the sheet which I have shared already, so that will be reached to you, you can utilize that. However, one time I'm also sharing that with you here, so that it will become more reconsider this file specifically. So that is here. So that is specifically the three layer of structure, where is the different types of the approval you required under the factories. Then after when that you obtain the different types of approval, that is conditioned with you, and there are the instruction provided on the condition that approval has been granted, so that you need to be assured and implemented. With that condition, there are the different the connecting labor law or the secondary labor law, which you need to be assured that. However, every labor law in India, they have the objective of the three major objective: health, welfare and safety, that need to be assured. So I think the question is clear now. So let's begin further in this session. So however, it is the 7 now, so within the next 15 to 20 minutes we have to cover this session. However, it is going to be the most long session from our side. So let's begin further. The next, understanding the process, how you have to reach to this level, how you have to assure the compliance in your organization. Compliance doesn't mean that you are just assuring the document, that is just the record. But compliance is to, you need to be aware about what is happening in the future, what are the changes happen, what is the law specifically. So that is actually the compliance. So now let's understand the process of the compliance, how you have to assure that. So here we have specifically designed the different types of the format, which will help you to implement in that. So when you go for the internal compliance, it can be do by yourself. You have to just utilize the master checklist which we have shared with you, and then you have to, whatever the gap happens, so you need to be incorporate in the another template which we have designed for you in the this process of the labor law compliance management portfolio development in your organization. So what is that? So I'm sharing it here with you. Compliance. So what you have to done, whatever the gap you have assessed and you have evaluated utilizing that master checklist, that you need to be incorporate in that. This is your planner, how you have to start the process of compliance with your organization. So there some is the due date you have to define, then in what month you have to complete that, in the month you can divide it in the week, and then after you can divide it in the day. So there should be one plan, and then actually when you have to done it, when you implement it as per the due date you have defined, so it will automatically assure that the your system or your way of working, the working style, that is the most progressive, and it will get the result automatically. So when you develop this concept or implement this concept in your organization, so that you do not have to hide it, so that you need to be display that in the beginning, I have shared with you the one template which you have to display, that is that the printable on the A3 sheets, that you can display that your desktop as well as your desk, where everyone can visual that. So this is the one of the systematic way we are sharing with you. Then you have to incorporate that, what is your plan, whatever the gap you have identified. So for that you have to make plan, so accordingly whatever all the requirement or based on the gap you found, so that you need to be assured and implement that based on the plan, and then make it sure it should be complete before the timeline you have given and you have provided to your plan. So this is the template specifically which will help you to make you more accountable. When you work with the PDCA or have the plan for you, then implement that as per the schedule, as per the due dates you have defined for that. It will help you to make you more accountable. This is the third number skill of the labor law compliance specialist. And when you have to implement the labor law compliance, so you can also initiate the labor law compliance committee in your organization. Then you can utilize the senior people of your organization 1 and 2, who will give you the third party viewpoints, so that if you lack something, so they can give you the idea and help in that. Then it come to the second layer of the labor law compliance special. Even national festival holidays are different. So there is one question that the now the minimum wage and the statutory record etc. are state-wise different. Will that be one for the throughout the country? No, that cannot be one for that. State-wise, that what is the change? When there is the central law, so you need to be understand that the basically there are not such changes. So change is only the something in the due date. Otherwise, it is same to all the state. And there are the change in the there specifically when you have obtained such approval, so there is the that the fee, that is the change. And even though the process is the same to all, so what you have to do in this template, you just have to incorporate the same process when it comes to the factories. For example, it is the factory, whatever the rules, whatever the norm, that are the same. Rule what say? Rule only say you have to provide this data in two format. In other state it is just for one format. In the third state it is the three format and three type of data, but that is equally same. So then it come to the next level, the next layer of your process. Then it come for the agencies. Okay. However, you are talking about the even national festival holidays are different. That are same, but it is the minimum requirement provided under the state specific, that you need to be assured something, but that are the same also. That is the cultural. We have the diversity in India, so that's why it could not be same. National holiday are only always same. That the three national holiday only available in India, that is the 26th January, 15 August and 2 October. Only these three national holidays. After that are the festival. So festival holidays depend on the organization. So that the law did not make them you have to give it 15, you have to give it 9, you have to give it 6, but the minimum assurance is provided there. Law does not say that you have to assure the specifically too much. That is the minimum mandatory requirement assuring by the law. So Alam is please keep your question at the end so that we can cover up all this system first, then we will pick up all the question your. So keep all the questions. For that I will provide the clarity on the minimum wage. And then the next process in the when you have to develop the process related to the labor law, then it come to the, if even you are utilizing the agency, for example you can utilize this template for if you are service provided to the organization, you have the client, so you are going for their assessing of their organization based on their current status of the labor law. So you can utilize this particular, it is a design based on the contract labor, but as per the factory you can utilize the first one. And then you have to evaluate the everything what is applicable as per the law, then what are the due document for that, then what is their current status, then what are your findings for that, and further what is your action on that, and when you have to require to implement that. So you need to be assure it, but it the practically implementation by the your contractor, your agencies, your vendor. So what you have to do for that ideally, so you need to be plan a schedule the quarterly assessment or their audit and inspection for complying their norms, or the not their norms, the labor law norms. So this is the template, it will be reached to you as it is, which you can utilize for evaluating, assessing your agencies to fulfilling the requirement of the compliances in your organization. So then it come to the next one, the third, the most important layer in the process, that is related to the when there are the inspection happen by the government agencies. So that is the one of, as I mentioned in the beginning, mostly the organization they maintain their compliances to represent to their management, but you are the representative of your management, you need to assure the compliances as per the labor that the authority. So how you can assure that? You should have some tool there. So that's why we are providing the tool to you so that you can assure every compliance in your organization which is required under the different labor law. So here one tool, however it is from the state specific, but you can refer it to all the state. So changes which I have mentioned specifically, there are the normal changes related to the document, related to the small condition and fee, and then divided it in the different document or the composite documents. So here this is the one template we have arranged from the state of Haryana specifically, and you can utilize it throughout the India. So basically there are the small changes in the different state of their rules. However, the master template we have prepared, it is based on this process, internal process of the agencies, and that you can, when you implement this system in your organization, when the inspection happen, when they give you the non-conformity, you can counter to them why and how it is happening. Law is saying that your internal system in that, so that they cannot question you, re-question you and counter question you that how it is not done and you are saying what. So specifically the master checklist we have prepared for you, that is based on the internal system of the agencies, how they inspect your organization. So they have their internal documentation available, based on that they will inspect your organization. Everything is mentioned there, who will be inspected, what are the norms, what are the regulation, what are the rule, and referring their section of the law, so that has been defined immediately or exactly. You need to be follow the same process, that process we have been shared with you. This is the template, what is the requirement, where the hazard process you required, and what is the maximum number of the hazard you need employ in that the working condition, what is there, who will be responsible for that, who will be inspecting under that. So you can ask that. Sometime it happen that the on the duty and the responsibility of the deputy joint director, but there one of the lower level of inspector come and she asks thousands of questions to you, when he it is not in periphery of him, so how he can ask. So this template will help you to counter the authorities that it is complying with their internal norms, and what they are taking care for, that how their system work inside. So the master template which we have prepared, so that is based on this master template or this internal process of the agencies, what required under which rule, which section, what they will look after, and what are the different forms. However, this is for the state specific, but in that you have to change the as per the form, like in the related to some considering of the like factories. So there is the form number 2 which is required the application submitting for the license of the factory, but in some state it may be the form 1. Even though the document application that you need to be furnish the data that are the same, but it can be only the form number change in the different state. So that is the minor changing in the different state rule in differently as well as from the central rule. So this is the template which will be reached to at EasyIt, so that you can utilize it for your implementation and understanding further. When you have to understand and learn, when this video will be available for you, you can refer these document and videos to re-understand and refresh your knowledge related to the managing of the labor law compliances. So this is about the second layer or the second pillar. Then it come to the third pillar related to the this portfolio management. The portfolio management means the labor law compliance portfolio management in the organization. So let's begin with the third layer. So third layer is specifically that is the now reporting. You have done all your work, and now it's time to, you have an employee, you have a progression, and you require to be represent your organization. You should have appreciation in the organization. So for that, however, earlier I have mentioned that mostly the people who are responsible for the compliances, they assure the compliances for their management. They present it to their management and they assure that it is all done, but actually on the ground it is not. When you implement this concept, you do not have to present in the many hours and explaining everything. This will be help you to present just in the 10 to 15 minutes, and otherwise your work with the system will be automatically represent your progression as well as your style of working and system in the organization. So for that, here is one template which we have prepared specifically for you, and when you utilize this template, it will help you that rebuild your credibility in your organization, as well as this will also help you to develop more confidence on you by your employer. So how is that and what you have to do exactly there? So I'm sharing it with you here. What you have to do, this is just one pager template, and which you can, this is here specifically what you have to do. We have understand in the beginning there is a three layer structure of the compliance, so that you need to be add up all those. In the part of the first layer, what are the compliances, what is their status, then in the second layer, what are the record you require to be maintained, and what are the compliance status you need to be submit. Accordingly, you have to incorporate that in the one pager template. Then if you are managing the different location, and for that you have to incorporate that their status, you need to be represent that to present to your management, and within the 5 to 10 minutes or maximum 15 minutes your reporting will be finished. And if your management have the question further what you have exactly did, what they want to see, so there is the another template we have prepared with it for you, so you can utilize it. That it is based on the status of the month, your frequency, what are the forms, what are the record you are maintaining, what are the your actions. So in which month you are presenting, what is the status, you can share that. And similarly, what are the status of the different types of the approval, what are your action as of now, what have you done, so that you can be assured here. But you have to first start with it. When they have the questions, so they will ask, so it will be develop the confidence on you, and it will make you more responsible for the organization. When they develop the confidence on you, it will assure that you are responsible for the organization. So these are the 4 different skills which required by a labor law compliance specialist to implement the labor law compliance portfolio in organization, and that will help you to create the your career USP and succession in the organization. Then it come to the next one in the presentation. So there we have separately one dashboard provide you, where we have incorporating near about 18 number of the existing labor law, which will help you what exactly you require under these different labor law, what you have to assure for the organization, and then how it will help you to do not go and run anywhere, so that getting the information related to the different existing labor law and its compliance. This is one of the broader compliance dashboard which we are going to share with you, and that will help you to understand what you required under the different labor laws. So it is the broadly where we have covered near about 19 number of the existing labor law. There we have incorporated everything what is required under the law. So like if we go for the EPFO or specifically under the factories, so what is required and which are the form you required, what are the information in that you have to submit, what are their relevant clauses, and what you have to submit in then to whom have to submit. So that guidance we have provided in this master dashboard, which we are sharing with you for your implementation and utilization. So this document will be reached to you as it is for your references and the learning, and with referring to the video session which we have done or which we are completing today, so that you can utilize all your learning and understanding near in the future. Law compliance management portfolio, where we have learned and discussed the three different pillars. When you have to work with this concept, and it will help you to progress, become a more systematic, and develop these four quality of the level of compliance specialist. That will also make you your career USP for your career progression, and branding yourself as the brand value give to you, so that you can progress in your career. So this was all in the section number 2. Now jump in the section 3. So section 3 is related to the question and answer. What are your questions? So keep it ready. And before that, I'm taking your 5 minutes. So here I'm sharing you with one the next level of the program in this labor law compliance mastery as a specialist. So what is that program and how that will help you to make the specialist in the labor law compliances and progress it in your organization. So basically this program we have designed specifically developing the practically these 4 skills within you, then enhancing your career and the credibility in your organization, and make you as a specialist in the labor law. So there what you are getting specifically, this program is the 30-day live session program, where we will work on the practically learning of the what are the exactly you required in the labor law compliances. So there we will practically work on together, where we will design different types of the template which you can utilize at your workplace, and then further there whatever the live session we have, there you will get the lifetime video recording. When this live session will be completed, then after there will be 2 monthly session for your updates and related issue and the labor law issues. Then whatever the templates we will design, that will be provide you for your personal custody, and finally when you will complete this program, you will be provided the completion certificate. Then further, this is the weekend program, and it will be happen on every Saturday and Sunday. 2 hours of intensive practice learning. It will be from 8 to 10 p.m. and 30 minutes of question and answer. So this program will be 2.5 hours total with the question and answer confirming. Then what we are exactly working and how the flow will be. So there we will be discuss first the overview of the law. Every day we will cover one law, and then the practical aspect of that, how you have to arrange the data, how you have to validate that, how you have to process all that documentation and implementation, every regulation in the organization. So we are covering all that. Then the new session which is starting, and we are engaging the new session from the 18th of December, Saturday 8 p.m. And then exactly what you are getting in that, so there will be 30 plus number of the existing labor and 4 new codes we will practically learn, and that will be based on the total you will be get the 75% of the assured practical learning, and where we will be learn through the WST technique which we have developed for the learning and practical learning of the learner. Then exactly we are covering the 33 existing labor law with the 4 new codes, and we have divided it in the 10 different modules related to the law. So what are those? So specifically we can check it here in the curriculum of this program. So there are the different law which regulate the working hour. In the module number 1 there is a 10 or 11 existing law which we are covering. Then module number 2, where the existing law we are going to be cover related to the wage, their practical aspect. Then the law related to the industrial relation we are covering in the different module, their practical aspect related to our technique which we have developed. Then the law which define the equality and empowerment of women that we are going to be develop and we learn practically in the module, another module, the module number 4. Then module number 5 is specifically related to the social security, all that existing labor law we are covering with the in the social security code or the in the social security related module. Then the law which are specifically regulated the prohibitive labor in the organization, that will be separately practice in the another module, and the one separate module is taken for the law which define the employment and training in the organization, and the law which specifically define the companies. And companies means what are the role of a company secretary in the organization, and then the impact of and how you can design a income tax friendly structure in your organization, so that you are going to be learn. Then the separately the law related to environment and the disaster, we are separately practical learning what you required under the pollution and factories, how you have to obtain the NOC for that, and further what are the compliances you required when there are the certain inspection happen. Then the module number 10 is specifically related to the 4 new codes. So practically we are going to be learn, and more probably we are going to be prepared practically and becoming ready when these new codes will be implemented from the April 2022. So exactly there will be more than 75 hours of intensive learning with these 34 existing as well as the new labor code. 37 33 existing labor code act and the 4 new labor code, we are covering the 37 codes, some 37 law in this mastery program, and which will be weekend program, and it will completed most probably in the 15 or 17 number of weeks. So now it will become, so maybe you have a question if anyone wants to go with this, so it will become through the part of the costing. So what will be the cost for that? However, the maximum retail price which we have assessed for it, it is the 49,499. But however, in this program, for the member who are already becoming the community member of the our great learning lead community, so we are offering them a specific concessional fee which you have to, or the, who are desire to go with this program, they just have to pay 2999. So this is the exclusive price for this program with this live session. If you go with this program from the other platform like direct from our website, it will cost for you 6,000 rupees, 5999. But in this program live session we are offering this least price and the concession fee of 2999. But addition to this, it is not just here, it is for the like free of cost for you. Addition to this, with this live program you are getting the 2 additional courses which are the majorly required essential program, and everyone should have that. One is the website mastery program, where you can learn design and develop the website for yourself, as well as you can start the freelancing. Second, which is one of the another, the advanced Excel program, which is the essential, and every industry, most of the 95% of the industry, they are using the Excel for their business day to day. So there the you are also getting with this program the Excel mastery program free of cost, that both worth for the 28,000, and this is for the today only. So now it comes to the question that how you can pay that. So if anyone want to go with this, so there are the 2 platforms already, Paytm and Google, they can utilize, but further we assure that it should be through our Scare PayU system. So there one link will be provided to you if you want to go with this program, so they can check out that link and go further this program. So here I am sharing the link with you, you can check out the link, and Then we will cover up all your questions, and if you have any question related to this program, so you can also ask those questions. So here I'm sharing the link for you, so you can check out this link if anybody want to go with this program of the mastery program for becoming the labor law compliance specialist. So you can check out this. And now this is the time for taking your question. So whatever the question you have, you can ask now. So then after we will bind up this session today. However, we have covered specifically the future perspective of the labor law, what is going to be happen, how you can become ready for that, even that as per your professional front as well as the requirement of the organization. But in the future, the labor law compliance specialist is going to be a bigger demand for the organization. As the law are changed and reformed, there are the tremendous changes which will impact the organization. So organization, they will require the more major and more professional who have the practical understanding in that. So that's why we have designed this second level or the next level of the program. And secondly, there is one a question also. So question is that is question specifically we are have the certificate for this program. So how the certificate will be provided to you? So that will be certificate released on Wednesday. So for that you have to share your name. So where you have to share your name, you can share your name on the platform you have provided the WhatsApp group, and you have also will be reach the document with the mail, and then you can revert your name till the Tuesday or Wednesday before 11 a.m. So then after we will process all the certificate by Wednesday, and that will be reached to you on the same day. So someone is raising the hand, Mr. Alam, if you want to question invent layoff and superannuation, so that separately we have covered it in the industrial relation, the next level of program. So that there you can also check out it detail and learn about that. It is specifically when it comes, there are the norms specifically prescribed there you required. If it is the more than 50 number of the employee in your organization, you required the approval for the retrenchment, layoff and the superannuation. So superannuation specifically it is on the attaining of the age. However, the organization they have developed their VRS, voluntary retirement scheme, by the age of 50 or 55. So for that you have to design separate policy for that. Superannuation, one is automatically coming on the age of superannuation, and second one that is different when you go for the VRS, voluntary retirement scheme. That is one of the superannuation scheme. But further, the retrenchment and layoff will also be in two cases. Retrenchment will be in cases of if your organization is not functioning financially and you are not capable to provide the employment to the organization. So for that you can go for the retrenchment, and that retrenchment is permanently, and then you have to assure the compensation to them. So compensation what you required, so that will be based on the period what they have served and as per the condition you have signed with them or you have with the employee. And further, in the one formulation which you required to follow in the retrenchment, so it should be the first in last out. So last out first in principle need to be apply for the retrenchment. If you go in the Industrial Dispute Act 1945, so there is the section 25, there is the subsection of the 27 number, so that is related to the retrenchment, how you have to manage that. Then layoff is specifically for the shorter period of time, means when the organization they don't have, there's some material available, they don't have some energy available, and some specific department they want to shut for some time. So layoff is for some time. So for that you need to be assured. However, it is a bigger number, so you need to be get approval for that. If it's a lower number of the 50, so then you do not have to need the approval from the authority, but you need to be make the assure that for first 45 days you need to be pay at least full salary, and then for other 50 days 90 days you need to be paid then 50% of wages, and then after how long it will be you need to be considered according to the law. So if no further questions, we are binding the session it here. So it is today the maximum, the longest number of the session. So by the 3.5 hours we have spent here together. So most probably I hope that you have learned too much from this program. So expect from tomorrow when you resume back to your office, so implement this concept so that it will help you before implementation of the new labor code. It will help you to provide you the confirmation what you have to do in your organization and how you can make compliance of all the regulation, even though in the existing labor law and then coming new labor 4 codes. So hoping that it was a good learning for you, and everyone I'm requesting that share your feedback on the WhatsApp group as well as through the email wherever you see and you feel that it is comfortable for you. So please share it there, and further don't forget to share your name. So however and that the enlighten and the about the restructuring of the pages. So what we have to do for the further means when the new code will be implemented, so there you need to be implement the concept related to the which are going to be happen the 50% of the gross salary. So for the law there is not your the concept of the CTC, that is not justified. So there is specifically the wage of the gross wage you are providing or you are paying to your employee, that is the considerable wage for the employee or for the law. Yeah, this is as per the according to the new code which I have already been shared with you. So there you need to be conceptualize the 50% of wages. What is the 50% of that wages, gross wages you are paying? So there 50% should be basic wage. So basic wage is including the minimum wage as well as the your dearness allowances. But in case if you are just paying the minimum wage to any workman, so that should be all in the basic wage. So this is the concept related to the restructuring of the your wage specifically, which you can utilize. However, we have shared with you the template you can utilize is that if you need to be broadly understand it and practically, so it will take around 5 to 6 hours. So that is the separate module we have available in the specialist mastery program. You can also check out that. So component it depend on, it doesn't, you can keep a one component also, like there is a basic wage, then there is the your retaining allowances. So retaining allowances it does not define that what it should be, but then the income tax has been defined where is the exemption provided, like there is the HRA, there are some exemption, there is the washing allowance, there are some exemption available. So there are the that the leave travel conveys some exemption on the income tax. So your that the structure of the wage or the salary that is based on the income tax, when there is the some exemption provided under the section 80 C, D and G of the income tax, so that accordingly you need to be define your structure so you can create the that income tax friendly structure for your employee. So there we have the separate module in the in the module number 9 related to the income tax, where we will design the thoroughly the salary structure for the bigger organization and the lower organization standardized as per recommended with the law, so that we are going to be, and practically how you can implement it, that we are going to be covered there. So if any further question available,